Okay? So, with that in mind, we have constitutional grounds then upheld by the Supreme Court for the Civil Rights Act of 1964. Okay? So that's a very important piece. Now, the following year in 1965, Congress passes the Voting Rights Act. This is also goes right up there, I think, with the Civil Rights Act of 1964 in terms of important laws passed by Congress. That the Civil Rights Act of 1964 would be high up on the list, and I think right up there with it would be the Voting Rights Act of 1965, which prohibited racially discriminatory practices by states in voting and empowered the Department of Justice to oversee elections in states that had historically or contemporaneously practiced racial discrimination. In other words, under our Constitution, I've mentioned this to you in a different context, we don't really have national elections in this country. Even presidential elections are not national elections. Under our Constitution, the states, we have 50 different state elections for president. It's a more accurate way of saying it. It's unwieldy to say it that way, and nobody says it that way in the media or in just general discussion. We're just talking about a national presidential election, but it's really not a national election in the sense that the states run the election, and the election laws are different from state to state. So, with that in mind, what Congress is saying in 1965 is, you have all of these states, mainly southern states, that historically or presently, that's what I mean by contemporaneously, at the time of the passage of the legislation, had various devices that discriminate in voting, discriminate on the basis of race. Do any of you know enough about this part of our history to give me an example of the kinds of things that might have been at issue? Well, we generally put them under the heading of Jim Crow laws, but anything specific that you know of that would have applied to voting practices that this is a literacy test would be one example. We get into this, I get into this a lot in the 2306 course, so maybe that's something for you to look forward to when you take the government 2306 course, whoever you have, maybe we'll get into some discussion of the specifics. But there were all kinds of devices used by states, particularly southern states, Texas, for example, that it's pretty clear that the purpose was to prevent minorities, particularly African Americans, from exercising their right to vote. And so what Congress is saying in 1965 is, that's no longer going to be tolerated. We're wiping all that away. States aren't going to be able to enforce those kinds of laws anymore. And furthermore, any time that they enact any new election laws, the Department of Justice is going to have to pre-clear it. If the state of Texas would be an example of one of these states, right? If the state of Texas passes a new law that has some effect on the election process, it's going to have to be pre-cleared by the Department of Justice. So, for example, in 2011, not that long ago, when the Texas legislature over in Austin passed a law that required voters to present photo ID before they could vote, presumably that would have had to have been cleared by the Department of Justice. And actually, that was an issue that was taken up by the Department of Justice, and that would have been during the Obama administration when Eric Holder was the Attorney General of the United States, and they found that the Texas law and other states that were trying to pass those photo ID laws were racially discriminatory. Okay? But in a case in 2013 called Shelby County versus Holder, this is not Shelby. There is a Shelby County, Texas, but this is not Shelby County, Texas. I think it's Shelby County, Alabama. Okay? The Supreme Court struck down the provision of the Voting Rights Act that required Department of Justice pre-clearance.